Rule 30. Trial. Section 1. Schedule of trial. The parties shall strictly observe the scheduled hearings as agreed upon and set forth in the pre-trial order. A. The schedule of the trial dates for both plaintiff and defendant shall be continuous and within the following periods. 1. The initial presentation of plaintiff's evidence shall be set not later than 30 calendar days after the termination of the pre-trial conference. Plaintiff shall be allowed to present its evidence within a period of 3 months or 90 calendar days, which shall include the date of the judicial dispute resolution if necessary. 2. The initial presentation of defendant's evidence shall be set not later than 30 calendar days after the court's ruling on plaintiff's formal offer of evidence. The defendant shall be allowed to present its evidence within the period of 3 months or 90 calendar days. 3. The period for the presentation of evidence on the third or fourth, etc. party claim, counterclaim, or cross-claim shall be determined by the court, the total of which shall in no case exceed 90 calendar days. And 4. If deemed necessary, the court shall set the presentation of the parties' respective rebuttal evidence, which shall be completed within a period of 30 calendar days. B. The trial dates may be shortened depending on the number of witnesses to be presented, provided that the presentation of evidence of all parties shall be terminated within the period of 10 months or 300 calendar days. If there are no third or fourth party claim, counterclaim, or cross-claim, the presentation of evidence shall be terminated within the period of 6 months or 180 calendar days. C. The court shall decide and serve copies of its decision to the parties within the period not exceeding 90 calendar days from the submission of the case for resolution with or without memoranda. Section 2. Adjournments and postponements. A court may adjourn a trial from day to day and to any stated time as the expeditious and convenient transaction of business may require, but shall have no power to adjourn a trial for a longer period than 1 month for each adjournment, nor more than 3 months in all, except when authorized in writing by the court administrator, Supreme Court. The party who caused the postponement is warned that the presentation of its evidence must still be terminated on the remaining dates previously agreed upon. Section 3. Requisites of motion to postpone trial for illness of party or counsel. A motion to postpone a trial on the ground of illness of a party or counsel may be granted if it appears upon affidavit or sworn certification that the presence of such party or counsel at the trial is indispensable, and that the character of his or her illness is such as to render his or her non-attendance excusable. Section 4. Hearing days and calendar call. Trial shall be held from Monday to Thursday, and courts shall call the cases at exactly 8:30 a.m. and 2:00 p.m. pursuant to Administrative Circular Number 3-99. Hearing on motion shall be held on Fridays pursuant to Section 8, Rule 15. All courts shall ensure the posting of their court calendars outside their courtrooms at least 1 day before the scheduled hearings pursuant to OCA Circular Number 250-2015. Section 5. Order of Trial. Subject to the provisions of Section 2 of Rule 31, and unless the court for special reasons otherwise directs, the trial shall be limited to the issues stated in the pre-trial order and shall proceed as follows. A. The plaintiff shall adduce evidence in support of his or her complaint. B. The defendant shall then adduce evidence in support of his or her defense, counterclaim, cross-claim, and third-party complaint. C. The third-party defendant, if any, shall adduce evidence of his or her defense, counterclaim, cross-claim, and fourth-party complaint. D. The fourth party and so forth, if anyone, shall adduce evidence of the material facts pleaded by them. E. The parties against whom any counterclaim or cross-claim has been pleaded shall adduce evidence in support of their defense in the order to be prescribed by the court. F. The parties may then respectively adduce rebutting evidence only, unless the court, for good reasons in the furtherance of justice, permits them to adduce evidence upon their original case. And G. Upon admission of the evidence, the case shall be deemed submitted for decision unless the court directs the parties to argue or to submit their respective memoranda or any further pleadings. If several defendants or third-party defendants and so forth, having separate defenses, appear by different counsel, the court shall determine the relative order of presentation of their evidence. Section 6. Oral offer of exhibits. The offer of evidence, the comment or objection thereto, and the court ruling shall be made orally in accordance with sections 34 to 40 of Rule 132. Section 7. Agreed statement of facts. The parties to any action may agree in writing upon the facts involved in the litigation and submit the case for judgment on the facts agreed upon without the introduction of evidence. If the parties agree only on some of the facts in issue, the trial shall be held as to the disputed facts in such order as the court shall prescribe. Section 8. Suspension of actions. The suspension of action shall be governed by the provisions of the Civil Code and other laws. Section 9. Judge to receive evidence, delegation to clerk of court. The judge of the court where the case is pending shall personally receive the evidence to be adduced by the parties. However, in default or ex parte hearings, and in any case where the parties agree in writing, the court may delegate the reception of evidence to his clerk of court, who is a member of the bar. The clerk of court shall have no power to rule on objections to any question or to admission of exhibits, which objection shall be resolved by the court upon submission of his or her report and the transcripts within 10 calendar days from termination of the hearing. Rule 31. Consolidation or severance. Section 1. Consolidation. When actions involving a common question of law or fact are pending before the court, it may order a joint hearing or trial of any or all the matters in issue in the actions. It may order all the actions consolidated, and it may make such orders concerning proceedings therein as may tend to avoid unnecessary costs or delay. Section 2. Separate trials. The court, in furtherance of convenience or to avoid prejudice, may order a separate trial of any claim, cross-claim, counter-claim, or third-party complaint, or of any separate issue, or of any number of claims, cross-claims, counter-claims, third-party complaints, or issues. Rule 32. Trial by Commissioner. Section 1. Reference by consent. The written consent of both parties, the court may order any or all of the issues in a case to be referred to a commissioner, to be agreed upon by the parties, or to be appointed by the court. As used in these rules, the word commissioner includes a referee, an auditor, and an examiner. Section 2. Reference ordered on motion. When the parties do not consent, the court may, upon the application of either or of its own motion, direct a reference to a commissioner in the following cases. A. When the trial of an issue of fact requires the examination of a long account on either side, in which the case the commissioner may be directed to hear and report upon the whole issue or any specific question involved therein. B. When the taking of an account is necessary for the information of the court before judgment, or for carrying a judgment or order into effect. C. When a question of fact other than upon the pleadings arises upon motion or otherwise in any stage of a case or for carrying a judgment or order into effect. Section 3. Order of Reference. Powers of the Commissioner. When a reference is made, the clerk shall forthwith furnish the Commissioner with a copy of the order of reference. The order may specify or limit the powers of the Commissioner and may direct him or her to report only upon the particular issues or to do or perform particular acts or to receive and report evidence only, and may fix the date for the beginning and the closing of the hearings for the filing of his or her report. Subject to the specifications and limitations stated in the order, the Commissioner has and shall exercise the power to regulate the proceedings in every hearing before him or her, and to do all the acts and take all measures necessary or proper for the efficient performance of his or her duties under the order. He or she may issue subpoenas and subpoenas duces tecum, swear witnesses, and unless otherwise provided in the order of reference, he or she may rule upon the admissibility of evidence. The trial or hearing before him or her shall proceed in all respects as it would if held before the court. Section 4. Oath of Commissioner. Before entering upon his or her duties, the Commissioner shall be sworn to a faithful and honest performance thereof. Section 5. Proceedings before Commissioner. Upon receipt of the order of reference and unless otherwise provided therein, the Commissioner shall forthwith set a time and place for the first meeting of the parties or their counsel to be held within 10 calendar days after the date of the order of reference, and shall notify the parties or their counsel. Section 6. Failure of parties to appear before Commissioner. If a party fails to appear at the time and place appointed, the Commissioner may proceed ex parte or in his or her discretion adjourn the proceedings to a future day, giving notice to the absent party or his or her counsel of the adjournment. Section 7. Refusal of witness. The refusal of a witness to obey a subpoena issued by the Commissioner or to give evidence before him or her shall be deemed a contempt of the court which appointed the Commissioner. Section 8. Commissioner shall avoid delays. It is the duty of the Commissioner to proceed with all reasonable diligence. Either party, on notice to the parties and Commissioner, may apply to the court for an order requiring the Commissioner to expedite the proceedings and to make his or her report. Section 9. Report of Commissioner. Upon the completion of the trial or hearing or proceeding before the Commissioner, he or she shall file with the court his or her report in writing upon the matters submitted to him or her by the order of reference. When his or her powers are not specified or limited, he or she shall set forth his or her findings of fact and conclusions of law in his or her report. He or she shall attach thereto all exhibits, affidavits, depositions, papers, and a transcript, if any, of the testimonial evidence presented before him or her. Section 10. Notice to parties of the filing of report. Upon the filing of the report, the parties shall be notified by the clerk, and they shall be allowed 10 calendar days within which to signify grounds of objections to the findings of the report, if they so desire. Objections to the report based upon the grounds which were available to the parties during the proceedings before the Commissioner, other than objections to the findings and conclusions therein set forth, shall not be considered by the court unless they were made before the Commissioner. Section 11. Hearing upon report. Upon the expiration of the period 10 calendar days referred to in the preceding section, the report shall be set forth for hearing, after which the court shall issue an order adopting, modifying, or rejecting the report in whole or in part, or recommitting it with instructions, or requiring the parties to present further evidence before the Commissioner of the Court. Section 12. Stipulations as to findings. When the parties stipulate the Commissioner's findings of fact shall be final, only questions of law shall thereafter be considered. Section 13. Compensation of Commissioner. The Court shall allow the Commissioner such reasonable compensation as the circumstances of the case warrant, to be taxed as cost against the defeated party or apportioned as justice requires. Rule 33. Demurrer to evidence. Section 1. Demurrer to evidence. After the plaintiff has completed the presentation of his or her evidence, the defendant may vote for dismissal on the ground that upon the facts and the law the plaintiff has shown no right to relief. If his or her motion is denied, he or she shall have the right to present evidence. If the motion is granted but on appeal the order of dismissal is reversed, he or she shall be deemed to have waived the right to present evidence. Section 2. Action and demurrer to evidence. A demurrer to evidence shall be subject to the provisions of Rule 15. The order denying the demurrer to evidence shall not be subject of an appeal or petition for certiorari, prohibition, or mandamus before judgment. Rule 34. Judgment on the pleadings. Section 1. Judgment on the pleadings. Where an answer fails to tender an issue or otherwise admits the material allegations of the adverse party's pleading, the court may, on motion of that party, direct judgment on such pleading. However, in actions for declaration of nullity or annulment of marriage or for legal separation, the material facts alleged in the complaint shall always be proved. Section 2. Action and motion for judgment on the pleadings. The court may motu proprio or on motion render judgment on the pleadings if it is apparent that the answer fails to tender an issue or otherwise admits the material allegations of the adverse party's pleadings. Otherwise, the motion shall be subject to the provisions of Rule 15 of these rules. Any action of the court in motion for judgment on the pleadings shall not be subject of an appeal or petition for certiorari, prohibition, or mandamus. Rule 35. Summary Judgments. Section 1. Summary Judgment for Claimant. A party seeking to recover upon a claim, counterclaim, or cross-claim, or to obtain a declaratory relief may at any time after the pleading in answer thereto has been served move with supporting affidavits, depositions, or admissions for a summary judgment in his or her favor upon all or any part thereof. Section 2. Summary Judgment for Defending Party. A party against whom a claim, counterclaim, or cross-claim is asserted or a declaratory relief is sought may at any time move with supporting affidavits, depositions, or admissions for a summary judgment in his or her favor as to all or any part thereof. Section 3. Motion and proceedings thereon. The motion shall cite the supporting affidavits, depositions, or admissions, and the specific law relied upon. The adverse party may file a comment and serve opposing affidavits, depositions, or admissions within a non-extendable period of 5 calendar days from receipt of the motion, unless the court orders the conduct of a hearing. Judgment sought shall be rendered forthwith if the pleadings, supporting affidavits, depositions, and admissions on file show that, except as to the amount of damages, there is no genuine issue as to any material fact, and that the moving party is entitled to judgment as matter of law. Any action of the court on a motion for summary judgment shall not be subject of an appeal or petition for certiorari, prohibition, or mandamus. Section 4. Case not fully adjudicated on motion. If on motion under this rule, judgment is not rendered upon the whole case, or for all the relief sought and a trial is necessary, the court may, by examining the pleadings and the evidence before it, and by interrogating counsel, ascertain what material facts exist without substantial controversy, including the extent to which the amount of damages or other relief is not in controversy, and direct such further proceedings in the action as are just. The facts so ascertained shall be deemed established, and the trial shall be conducted on the controverted facts accordingly. Section 5. Form of affidavits and supporting papers. Supporting and opposing affidavit shall be made on personal knowledge, shall set forth such facts as would be admissible in evidence, and shall show affirmatively that the affiant is competent to testify to the matters stated therein. Certified true copies of all papers or parts thereof referred to in the affidavit shall be attached thereto or served therewith. Section 6. Affidavits in bad faith. Should it appear to its satisfaction at any time that any of the affidavits presented pursuant to this rule are presented in bad faith or solely for the purpose of delay, the court shall forthwith order the offending party or counsel to pay to the other party the amount of the reasonable expenses which the filing of the affidavits caused him or her to incur, including attorney's fees. It may, after hearing further, adjudge the offending party or counsel guilty of contempt.